building upon the prior discussion of engaging in real estate activities outside one's area of expertise. This final section addresses the narrow circumstances under which a licensee may represent a client outside their field of competence. Arizona real estate law recognizes that growth and diversification are part of a licensee's career. However, that opportunity comes with strict professional obligations to ensure that clients are not disadvantaged by an agent's inexperience. A licensee may represent a client outside their field of competence only if they act under proper supervision, make full disclosure to the client, and obtain guidance or collaboration from qualified professionals. The governing rule, Commissioner's Rule R4-28-1101H, clearly states that a licensee must not act in a capacity that requires expertise beyond their competence unless they engage or obtain the assistance of a qualified professional. This requirement does not prevent licensees from entering new areas, such as commercial, agricultural, or property management transactions, but it mandates that they take appropriate steps to protect the client's interests. The rule's intent is to ensure that real estate representation always meets the standard of reasonable skill and care under R4-28-1101A, regardless of the licensee's level of prior experience in that specific field. For example, a residential agent who is approached by a client seeking to purchase an office building may still represent that client, but only if the agent discloses their limited commercial experience and seeks assistance from a qualified commercial broker or mentor. The client must understand that while the agent is licensed, their experience in that specific property type is limited. This disclosure allows the client to make an informed choice about whether to continue with that agent, obtain co-representation, or seek another professional. If the agent proceeds, they must ensure that they are supervised by a broker experienced in commercial real estate or work collaboratively with one who can provide oversight and review the transaction documents. Disclosure of limited experience is not only a best practice, it is a legal requirement. Failing to inform a client that the agent lacks relevant expertise could constitute misrepresentation or concealment under ARS. Section 32-2153A3, which authorizes the commissioner to suspend or revoke a license for acts of bad faith, dishonesty, or untrustworthiness. The principle was reinforced in the Arizona case, Lombardo versus Albu, 1996, which held that a licensee's duty of reasonable skill and care includes recognizing personal limitations and seeking assistance or disclosure when appropriate. The court ruled that agents who fail to disclose their lack of experience or knowledge may be held liable for negligence if their inexperience leads to client harm. When representing a client outside their field of competence, a licensee must also comply with the broker supervision requirements outlined in R4-28-1103A. This rule obligates brokers to establish and enforce written policies, ensuring that agents receive proper guidance and review when performing unfamiliar transactions. A broker who allows an unsupervised or untrained licensee to conduct complex real estate activities can also face disciplinary action under ARS. Section 32-2153A21. Therefore, a broker's mentorship, review of documents, and pre-approval of client communications are essential safeguards when expanding into new specialties. Another condition that must be met is the involvement of qualified professionals when specialized expertise is required. For instance, if a licensee helps a client purchase raw land for future development, the agent must recommend consultations with land use attorneys, surveyors, and engineers who can address issues like zoning, topography, and infrastructure feasibility. Similarly, an agent handling their first property management contract must consult their broker and understand the trust account and record-keeping requirements under ARS. PRFR 32-2171 through 32-2176 before accepting responsibility for tenant funds. The key is knowing when to rely on experts and ensuring that those referrals are timely and documented. Representation outside one's competence also requires transparency and record keeping. According to ARS Section 32-215, 1.01a, all disclosures, referrals, and supervisory communications must be maintained in the broker's transaction file for at least 5 years. This record serves as evidence that the licensee acted in good faith and in compliance with statutory obligations. A licensee who can demonstrate that they disclosed their limited experience, obtained supervision, and referred the client to qualified professionals is far less likely to face disciplinary action if complications arise. A practical example illustrates this. A residential licensee is hired to assist a buyer in purchasing a multi-unit apartment complex. The agent immediately informs the client that while they are experienced in residential transactions, this is their first multifamily purchase. They collaborate with their broker, engage a commercial lender for financing advice, and recommend the buyer consult with an accountant for income and depreciation projections. By making full disclosure, securing expert support, and working under active supervision, the licensee fulfills both their ethical and legal obligations while expanding their skill set responsibly. Review summary. A licensee may represent a client outside their field of competence only under 3 key conditions. First, full written disclosure of limited experience must be made to the client. Second, the licensee must be supervised by or collaborate with a broker or professional experienced in that field. And third, the licensee must engage or refer to qualified experts when specialized knowledge is required. These safeguards ensure that clients receive competent, lawful, and ethical representation. Violations of these standards may result in disciplinary action under ARS Section 32-2153, A3 or R4-28-1101H. The overarching message of this module is that professional growth should never come at the expense of public trust or client protection. Discussion prompts. Under what conditions may a licensee represent a client outside their field of competence? Answer: only when they disclose their limited experience, act under broker supervision, and seek assistance from qualified professionals. Why is written disclosure of limited experience important? Answer: it ensures the client's informed consent and protects the licensee from allegations of misrepresentation or dishonesty. How does broker supervision protect both the licensee and the client? Answer: it ensures that all actions comply with ADRI standards, prevents legal or ethical violations, and maintains professional oversight for complex or unfamiliar transactions. Closing remarks. The Arizona real estate profession values ambition and growth, but it equally values honesty and accountability. Representing a client outside one's field of competence is not prohibited. It is regulated to ensure that the client's interests are never compromised. By combining disclosure, education, supervision, and collaboration, licensees can safely expand their expertise while remaining compliant with Arizona law. The true mark of professionalism is not knowing everything, but knowing when to seek help and ensuring that every client receives competent and ethical representation.